The judiciary, our lovely third branch of government. So the judiciary, or sometimes the judicial branch, that's typically what we hear when we hear of the judiciary, or the Supreme Court, but it really encompasses all of our federal court system. The powers of the judicial branch, they're outlined in Article 3 of the Constitution. The United States, it has multiple layers of courts at the state and federal level, though, and often within states, the structure of the court hierarchy is pretty similar, if not exactly the same, to that in the federal court system. So, and one layer we have regular courts, we could say. I'll try not to complicate this too much. So you have your typical court you go to. Then after that, we have the Court of Appeals, if you're appealing the decision at that lower court level. And then the court at the very top would be the Supreme Court. And this is where cases often go at the end of their appeal cycle. That's for standard cases, but at another level, there's an entirely different sort of function of the Supreme Court when it reviews legislature. We'll touch on that a little bit later on in this video. So again, the Supreme Court, it's the highest court in the United States, and it reviews the constitutionality of laws. So it doesn't review standard criminal cases or civil cases. Instead, it's more so reviewing whether or not there was a constitutional violation in the proceedings, or the procedure of the particular case. All right, so Supreme Court judges, there's 9 of them, and they're called justices. So there's 9 justices, and they're all appointed or nominated by the president, and then they're later confirmed or accepted by the Senate. And they go through this lengthy vetting process before they're ultimately confirmed, and sometimes they are denied. And that has happened a few times as well. What is the role of the Supreme Court? So it is to have the final say on interpreting the Constitution. The judiciary, it's distinctive because it is the part of the government that speaks the language of the fundamental values of the political system. So when the Supreme Court interprets cases in a certain way or issues some kind of ruling on a case, they do so while trying to understand the entire scope of the United States political system and our historic values and also our values at the time. But it's more so our core values, these American political values that we see, these values of freedom, limited government, individualism, these sort of things, but also the very fundamental principles that are outlined in our Constitution, which is limited power, equality, freedom for all, as I said, freedom. But this limited power of the government is a strong fundamental value that we have in our American political system. But if we add to that, we also have the ideal of making sure we're all equal and that minority rights are protected. So there are a variety of different values within the American political system, and the judicial branch, they really get into the sort of language that is used within when we talk about American values. So the Supreme Court, it differs from the rest of the national or federal government in the following 3 ways. The judiciary operates only in the context of cases. So all they do is review cases and issue rulings and decisions on those cases. Second, the cases develop in a strictly prescribed fashion. And third, judges rely heavily on reason in justifying what they do. So there's a whole different set of procedure than what we might see in the executive branch or the legislative branch, where they have a ton of different things that they do. The Supreme Court is less convoluted, we could say, and the Supreme Court that we see today is very, very similar to the Supreme Court that we would have seen in 1789 when the Supreme Court was created. On the other hand, the other two branches of government, the legislative branch and the executive branch, they look very different than what we would have seen 200 some years ago. So we could say that the Supreme Court, they're very traditional and they uphold the traditional political and fundamental values of the United States that were instilled in our Constitution in 1789. And what those values are, it's sort of debatable, but really not. The core values, again, we have equality, freedom, individualism, limited governmental power, things of that nature. And I'm sure you can think of a few other examples as well. Judicial review. So judicial review is this power that the Supreme Court has that they can review laws that are made by Congress, and they make sure that they're constitutionally valid, that they uphold the constitutionality of various laws that Congress makes. So the Supreme Court gained the power of judicial review in 1803, and this was through the case Marbury versus Madison. I encourage you to look into that case again and familiarize yourself with it. Ultimately, it proved that the Supreme Court does have power over the legislature or the executive branch to make sure that those two branches are in line with the Constitution and constitutional values. The justices, the Supreme Court justices, they are the keepers of American constitutional morality. And Justice Robert H. Jackson, he stated, the people seem to feel that the Supreme Court, whatever its defects, is still the most detached, dispassionate, and trustworthy custodian that our system affords for the translation of abstract into concrete constitutional commands. So what that means is, again, the Supreme Court, they are the interpreters of the Constitution, and judicial review is essentially the interpretation of the Constitution, and it's the Supreme Court's authority to make sure that Congress and the executive branch as well are upholding their end of the bargain, so to speak, in making sure that the policies, laws, and things that they do are in line with the Constitution. Let's talk about checks and balances. So in the United States government, we hear this often about checks and balances. Power is balanced and it's also put into check as well. So the Supreme Court does have a significant degree of power, especially considering that they are the keepers of the language of the Constitution and of American political values that influence the creation of the Constitution. So if the Supreme Court has the power to rule that Congress is doing something that's not constitutional, one might think that the Supreme Court has more power than over Congress. It's true to an extent in that regard. And there is a little bit of unchecked power in the judicial branch, or in the Supreme Court, we could say. And one is that justices don't have to face voters. So justices are not up for election by the people, and the people can't vote them out. They are appointed by the president, they're confirmed by the Senate, and they have lifetime appointments. So they get to sit on the Supreme Court bench for the rest of their life if they so choose. They can retire, of course, but if someone is appointed in their 40s, they could easily be on the Supreme Court for the next 40 years. And the people, the American citizenry, they do not have the ability to really do anything about it. But again, that's just one part of the puzzle here, one piece of the puzzle where the Supreme Court does have some degree of unchecked power. but also their power is definitely checked. They do not have unlimited, unrelenting power. And how is judiciary power checked? One, through constitutional amendment. So we can change the Constitution. So that's one way that judiciary power could be checked, that that Congress, or it could be initiated by the states, that they decide that that we're going to add an amendment to the Constitution, and that might go against many rulings that the Supreme Court already had. So the Supreme Court has the final say with what the Constitution says, but the legislature, they have the ability to change the Constitution. But keep in mind, this barely ever happens. Again, there's 27 amendments, but there have been thousands that have been proposed and that have died and didn't go anywhere. But one example would be the 14th Amendment, and that overturned Dred Scott versus Sandford. 14th Amendment said that people can't be discriminated against based on their race, among other things. But Dred Scott, that had stated at that point in time that African Americans were not considered when the Constitution was written, and therefore the Constitution did not protect them. But then the 14th Amendment comes along, and that ultimately did lead to African Americans being protected by the Constitution. So that's an amendment created by the Congress that overturned a decision by the Supreme Court. So the Congress does have power over the Supreme Court as well. It's not just a one-way street. A statutory amendment, Congress passes a law that corrects the Supreme Court's interpretation of a statute. Statute is essentially just a law. Supreme Court judges, they can be impeached and they can be removed, but only 7 judges have been removed, and they're all from lower courts, so meaning it could be the Court of Appeals or district courts, whereas a Supreme Court justice has never been removed. Congress can withdraw jurisdiction. So Article 3 states that the Supreme Court has appellate jurisdiction. That means they have jurisdiction with their Court of Appeals, with the exception and under such regulations as the Congress shall make. So that means the Congress can prevent certain types of cases from making it to the Supreme Court by simply stating that the Supreme Court does not have jurisdiction over certain courts. Another thing that can happen, and it hasn't though, is that Congress can pack the court. And this was first proposed in 1937 by FDR, Franklin Roosevelt. And what this means is that Congress, or even the executive branch, I guess I'm not 100% sure if the executive branch has the ability to do this, it's likely just Congress, that they can add more justices to the Supreme Court. Right now there's 9, and that's how many there are, but Congress can pack the court and add more. And they might want to do this if they need, or if they think that they want more justices that have a particular political ideology, for example. So if you have if you have 9 justices that are, let's say 6 of them are conservative, 3 are liberal, a liberal president might get in, or a liberal Congress, and they might decide, well, let's add 3 or 4 more members, and we'll appoint all justices that have a liberal ideology. And in that way, then the court can issue cases in a way that are in line with a particular political ideology, instead of it being more of a neutral territory. And more, the Supreme Court is being infiltrated by this political ideology, both left and right wing. It's become a bit of a political playground for Congress and the president to find a way to ensure that their particular ideology is upheld by the court system as well. Another aspect too of this sort of check and balance of power for the Supreme Court is that the Supreme Court relies on compliance with other governmental officials, courts, and the Congress to carry out its decisions. So the Supreme Court has to sort of be a team player, but really they are pretty much completely impartial. They just look at the bare bones of the Constitution, they uphold the Constitution, but they do rely on others to make sure that their ruling is being carried out. So that makes it so that the Supreme Court can't just be its own powerful entity deciding what everyone else must do. There has to be a bit of, as I said, some team playing going along with it. This chart here outlines the federal court system in the United States. So at the top, we see the Supreme Court of the United States. At the bottom, we have district courts and various other courts that are more specialty courts. United States Claims Courts, United States Court of Veterans Appeals, so that just deals with veteran affairs, United States Court of International Trade, and then there's an entire military court as well. So you have these lower level courts where you go if there's something to do with federal law, and if the federal government seeks to prosecute you based on that law. If there's a state law that's overlapping with the federal law, often the state might just pick up the case and leave it out of the federal court system. Then the second level would be the Court of Appeals. So this is one of the beautiful things about the United States court system, is that we have this elaborate appeal system or appeal procedure. So you can be charged and convicted with something, but you have the opportunity to appeal that conviction. And appealing it means that you're saying it was wrong, the ruling was wrong based on something. And at the appeal level, usually that means like something was done wrong in the procedure, or it could be that there's some new evidence that comes out that shows that someone completely did not do something. And then there's the opportunity to have that information considered by the Court of Appeals. Once a person has exhausted almost every appeal possible, besides the very last one, then that case can go to the Supreme Court, where the Supreme Court reviews it. And at that point, that's where they're seeing whether or not something unconstitutional is at play in that case. It's all about, again, the constitutionality of that case. That's what happens once it gets to the Supreme Court level. At these lower levels, there can be other issues within the process. But at the Supreme Court level, that is just whether or not it is constitutionally valid, the ruling of the case. There are 12 different appellate circuits in the United States, and we can see them here based on geographic boundaries. Wisconsin is in the 7th Circuit Court of Appeals. And if any of you have watched Making a Murderer on Netflix, this detailed Stephen Avery, a man in Wisconsin who was charged with murder and eventually convicted. But often in that show, if you've seen it, they talk about the 7th Circuit Court of Appeals. And that's just what they mean. They mean this federal court system. The appeals court is located, I believe, in Chicago. And again, that's part of the 7th Circuit. And then that case did make it all the way up to the Supreme Court. I am not sure how that ruled. I think it did not rule in Stephen Avery's favor. So we see 11 numbers, but then DC, Washington, D.C., that's where the 12th appeals court would be. Let's look at the two types of law. What are they? It's natural law and positive law. So natural law, these are God-given, so to speak, rights that we have as humans, ones that we're born with, life, liberty, and the pursuit of happiness. And then you have positive law, and this is man-made law. Then we have two types of positive law, common law and there's civil law. So common law is law that is created through the courts. It's created as a result of the courts issuing some kind of ruling, and then later that becomes law because courts keep going back to that previous ruling and making the same one, sort of following this tradition of what the previous ruling was. So common law, it's also called case law, and then we can call it precedent as well. So the Supreme Court or a court may issue a ruling on a case that some kind of ruling that comes up, and it sets the precedent for later rulings. The English Bill of Rights, for example, that's all or mostly case law or common law, meaning that over time, English people were granted certain rights because the courts issued a determination on various cases that came before them. It could be a civil case, for example, and then later on, in some case hearing or procedure, the lawyer will often reference back to a specific case that set the precedent for the current case. So take a moment and think here about common law, case law, and precedent. It's all the same thing, and how that functions in our government and in our lives. So it's another kind of positive law is civil law. And civil law, these are laws that are created by the legislature. So these are our standard laws that we see, just laws that are created by the legislature, and common law is law that is created in the courts, and it's based off of case rulings. And you might hear this if you watch crime shows or lawyer shows, or if you have been involved in the civil or criminal system, you might hear that the precedent was set. This sets precedent for such and such. That's why some cases are extremely important, that they aren't heard, or that they are ruled in a certain way, because it could be an original sort of case that appears, and it's important that the precedent is set in a particular way, often for people involved, that it's crucial that there is not a incorrect or unwanted precedent that is set. So what's the difference between a civil case and a criminal case? Well, what's a case? A case, it's a dispute handled by a court. And a crime, it's a public wrong against society at large. So a criminal case then is a case brought forth by the government against an individual following the commission of a crime. So someone commits a crime, a wrong against society at large, and then it is brought forth before the courts by the government. The government brings the case forth. It's the government that is essentially going after the alleged criminal, and they cite the law in stating what they did was a criminal offense. A civil case, on the other hand, this is non-criminal legal action. So a law was not violated in any way, but legal action is being taken. And this could be anything from divorce to an attempt to recover some kind of damages following some sort of incident. And what that means is somebody's getting sued. Like, recovering damages means that you sued somebody. And that's a civil case. So there are federal crimes and there are state crimes. A lot of them overlap, but there are some that fall under the jurisdiction of one or the other, quite a few. And talking about the Supreme Court, we're talking about federal cases. So this federal judicial system deals with federal crimes. And federal crimes, this would be tax violation, drug trafficking, kidnapping, counterfeiting bills, immigration crimes, copyright infractions, child pornography is another example. Examples of common state crimes, we have traffic violations, contract breach, robbery, rape, and arson. So with state crimes, the state judicial system would handle those, and with federal crimes, those would be handled by the federal court system. The difference between state crimes versus federal crimes boils down to where court proceedings will occur, meaning the jurisdiction. For a state crime, court will be held in the city or county where the crime was committed. And for a federal crime, there are 3 levels to the court system: the district court, the court of appeals, and the Supreme Court. So you would go to the district court, and then you would go to the court of appeals, and then the Supreme Court. Obviously, there's going to be a lot less federal courts than there are state courts. I mean, if there's a courthouse in every single city, those are handling state crimes. There's not a federal court in every single city, or city or town of some size. So that's the difference. The states handle a lot more criminal proceedings than the federal court system does. There are some laws that overlap and are contradictory. So one right now is marijuana usage or legalization. And at the federal level, it is illegal. It is a Schedule I narcotic, and it is illegal to sell or possess marijuana at the federal level. However, certain states have allowed marijuana to be legal for recreational purposes, and others, significantly more others, they have legalized marijuana for the use of medicinal purposes. So it's a contradictory sort of thing, and there's a lot of gray area in this regarding possession of marijuana, and that can lead to a certain degree of confusion. So if one wants to buy a firearm, part of the process to buy a firearm states that one must not use drugs. But what if marijuana is legal in your state and you seek to go buy a firearm? You could be denied federally the ability to buy that firearm if you say you use marijuana, even though it's legal in your state, because it's still illegal at the federal level. And gun laws are typically a federal law. There are some gun laws that vary state to state, but gun possession, our constitutional right to own firearms, that's a federal law. There's federal jurisdiction over that. There was a similar situation with same-sex marriage a few years back under the Obama administration. And at that point in time, many states were legalizing same-sex marriage. And then at some point, the federal government stepped in and they said same-sex marriage is legal for all states. And that's something that we might see with marijuana laws as well, because it's sort of following a similar pattern where eventually the federal government might say, well, federally, we're going to supersede states' rights right now and not infringe on the constitutional rights of the American citizens in some way, and we won't leave it up to the states anymore. How does a case get to the Supreme Court? Well, in most criminal cases or civil cases, they'll go through the standard court process. You appear before the court. Later, there may be a trial and some kind of sentencing after the trial. And then after that, the appeal process starts. And one has this lengthy appeal process, and by the time they get to the end of their appeals, they've exhausted their appeals, they can head up to the Supreme Court. And what happens at that point is one's lawyer will petition the Supreme Court to review this case. And at that point in time, all records go to the Supreme Court. The Supreme Court, at that point, they decide if they want to hear the case or not. They can decide at that point in time that they're not going to hear it, or they can say, okay, we'll hear it, and then at that point they review the decision of the lower appellate court, and they study the record, and they question whether it is constitutional or not, or just get familiar with the case. Then they listen to the arguments from the lawyers. You have the one that is defending the client, and then there's the one that's just defending the appeals courts. After review of all of these arguments and the briefs and all of the records, that's when the Supreme Court issues a decision. And they can either overturn the decision and say they disagree with what the appeals court said, or they can say, we totally agree with what they said, we affirm it, and that's it. That person's completely run out of appeals. Or they can remand the case, which basically means that it goes completely back to the beginning and the whole process starts all over again, to the very beginning, pretty much. Well, to the trial court, at least. We have 9 justices. So how are they appointed? How do they become justices that now have a life term sitting on the highest court in the United States? Well, first, they're nominated by the president, or appointed. They're nominated first. And then there's this huge vetting process. A hearing, a committee vote, then there's debate on the Senate floor, some kind of filibuster, another vote, and then we can confirm the nomination. During this whole process, the person is thoroughly investigated about their character, things they've done in the past. They're questioned by the Senate Judiciary Committee, which has roughly 20 members. It's bipartisan. It has an equal amount of Democratic members and Republican members as well. And they're senators who question these nominees and investigate them, and they review them. It can be a pretty grueling Q&A session that goes on between these nominees and the senators. Eventually, though, then if they make it through this, then there's a vote by the Senate, and then the justice will be appointed, and they can now serve on the bench for the rest of their life if they want. So there have been a few controversies about people on the bench, and one person is Robert Bork. This was in the 1980s. He was nominated by Ronald Reagan. Eventually, he didn't make the cut, and then Clarence Thomas was nominated. But during his vetting process, it came out that there were some allegations of sexual misconduct at some point in his career, and this almost made it where he did not get appointed or selected ultimately. He ultimately did, and he's still sitting on the bench serving as a Supreme Court justice. But this is where we start to see this kind of scandal that comes about when appointing these justices. So if they're appointed in a way that seems like it's promoting a political agenda, or if they're selected based primarily on their political ideology, then it becomes crucial for the other side to find some dirt in their past to make it so that they do not sit on the bench, because they're going to be there for a long time. And that can set precedent for cases being determined in a way that might line up with a particular ideology that isn't wanted. Under the Trump administration, he appointed 2 justices, and each were extremely controversial. Brett Kavanaugh, he had sexual misconduct allegations as well, in the same way that Clarence Thomas did. Amy Coney Barrett, she had her own degree of sort of intrigue surrounding her nomination as well. And it was seen as Trump trying to manipulate the Supreme Court and have more conservative people on the bench than liberals, and then to especially have people that would be there for decades to come, most likely. So these were all conservative nominees or Republican nominees under Republican administrations. This sort of intrigue as well happens during or under liberal or Democratic administrations as well. However, this appointment process does not happen that often. So we won't see too many controversies because there's 9 people sitting on the bench and they sit there for about half of their life, and it does not happen too terribly often that there is the opportunity to appoint a new justice. However, we are in that process right now. We are in the process of appointing another justice to the Supreme Court, and it will be very interesting to see how this process unfolds. And to sum things up, the Supreme Court has the power to resolve social and political conflict, but it can also increase this sort of conflict. There's political conflict that surrounds the appointment of Supreme Court justices, but on the other hand, the Supreme Court has the ability to uphold or to overturn certain decisions, and they've done a significant service to minorities, especially in the civil rights movement, with upholding certain amendments. But they've also prolonged discrimination as well. So we have Plessy versus Ferguson. This was in the 1890s, this court case that was decided by the Supreme Court that ruled that segregation was constitutional as long as things were equal, separate but equal. That prolonged discrimination. This was a Supreme Court ruling, but later on, the Supreme Court did have rulings that upheld minority rights or women's rights as well. Brown versus Board of Education, Roe v. Wade, and other landmark cases as well. There are other courts as well that fall under the federal court system, and one is FISA, the FISA Intelligence Court, and this court deals with asking for permission to essentially spy on certain foreigners that may pose a threat to American national security. So there are certain applications that are made to the U.S. government for approval of electronic surveillance, physical search, and certain other forms of investigative actions for foreign intelligence purposes. Then there's the Alien Removal Court, and this is a special court consisting of 5 Article III judges selected by the Chief Justice of the United States. Its job is to determine whether aliens, meaning non-citizens of the United States, should be deported from the U.S. on the grounds that they are terrorists. The federal courts also deal with racketeering, or RICO laws. And racketeering, this is the act of acquiring a business illegally, so usually done through threats or extortion or things of that nature. And that's something that's handled through the federal court system. So the Supreme Court, they are the big dogs at the top of the federal court hierarchy. They are the ones that uphold the constitutionality of various cases that come before them. And they are the interpreters of the Constitution and the ones that really know, understand, and have a feel for American political values. And they use that sort of judgment when it comes to determining the ruling on cases in front of them. So again, the U.S. federal court system, this is the third branch of government. The powers are outlined in Article 3 of the Constitution. The president nominates justices to the Supreme Court, and the Congress is the one that confirms them, ultimately confirms them after a very long and thorough vetting process. And what we seek in the judiciary is a nonpartisan, non-politically aligned body that is only focused on constitutional law and the Constitution. However, what we've been seeing in the U.S. as of late in the last few decades is that the Supreme Court has become a battleground for political ideology and how people seek to have laws interpreted in the foreseeable future. So that's all things to consider and think about. And one thing to consider too is that there are a vast array of federal laws out there. So distinguish also the difference between federal law and state law and how something might appear before the federal courts.